Hello and welcome to another View from Mayer Brown, an occasional series of interviews with those involved in the changes going on in employment law. This sits alongside our regular fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. The podcast is presented by Nicholas Robertson, the head of Mayer Brown's London employment team. This podcast is available via iTunes, YouTube and the Twitter feed Nicholas Robertson, Twitter handle @NicholasRobert11. It is also now available on Spotify, Google Play and Yahoo. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to The View from Mayer Brown. This is a special guest podcast because I'm delighted to be joined by Pauline Moritz, who's a senior associate in our Frankfurt office in the employment and benefits practice. She advises on national and international undertakings and covers the whole range of issues on individual and collective labour law and managing director contract law. Pauline has experience in providing advice on establishing and terminating employment relationships, typically at the managing director level, and preparing and carrying out reorganisations, outsourcing and staffing adjustment measures. She focuses on the deployment of external personnel. She advises German and multinational companies with investigations by the relevant authorities, including customs officials, and where there are risks of personal liability, including sometimes criminal liability, in connection with alleged evasion of social security contributions. If there's one thing that English employment lawyers know, it's that German employment law is different. It's different and it's difficult. I'm quite sure the German employment lawyers say the same about English employment law. But I thought it would be fantastic if we could ask Pauline to come on the podcast today and ask her really for some sort of basic illustrations of differences in approach in terms of German employment law and English employment law. And so we are really delighted to have you with us, Pauline.
Thanks for having me, Nick.
Good. I ought to say, by the way, we have high expectations this podcast because you are a podcast presenter yourself on the German Employment Podcast.
That's right. We do a podcast for...
Yes, and it's briefing for HR. It's an HR briefing podcast.
Exactly, and we cover all kinds of employment and labour law aspects that are being recently handed down by courts or new developments.
So a similar sort of focus to the podcast that we do here. That's right. Perhaps not entirely coincidentally, who knows. But what I'll do, I'll post out a link with this podcast episode to the German podcast, but only against an undertaking you do the same for this podcast.
Of course I will.
Excellent. Well, listen, genuinely delighted to have you on board. I thought maybe the best way of starting would be, let's start with the sources of law, because obviously, as you know, in English employment law, you've got statutory law, and then everything else, by and large, comes down to the individual contract. And that's why there's this colossal freedom to negotiate. Parties can basically agree what they like with relatively light touch from statute. So what are the sources of law that govern German employment relationships?
Yeah, I think it's relatively similar to the UK law. Of course, we do have the employment contract that's individually negotiated. Sometimes we have unionized employees, and in that case, collective bargaining agreements set forth further provisions. We also do have works council agreements that cover a lot of issues and that are binding for all employees in that relevant company. And of course, we do have statutory law. While we do not have a labour book code or the Employee Rights Act as you have in the UK, but we have several different acts that cover all kinds of employment law, like the Working Time Act, Dismissal Protection Act, Works Constitution Act, so all kinds of different acts. And of course, there's always case law that we have to take into account.
So, is it fair to say that the individual contract between the employer and the worker has perhaps less autonomy, less freedom than it would in England, where you have statute and then the collective labour law, by and large, has disappeared? Yes. There are unionised workforces, but they're a small minority.
That's true, and also German employers are pretty limited in what they actually put into a contract because we have a very strict terms and conditions law. Right. So any provision in a contract that's not compliant with terms and condition law will be invalid and thus not enforceable. Okay. So you really have to pay attention to drafting proper contracts in Germany.
Interesting. One of the things that I think I found clients typically struggle with when they come across continental Europe, but let's focus on Germany, but continental Europe, is this whole business of works councils and the role played by them. And I have some clients that start from an assumption that works councils are a bad thing because they stop you doing what you want to do. So let's talk first of all, the role of works councils. Are they mandatory in German companies, and their precise role? Just talk us through that.
Sure. Well, Works Council is, of course, a big issue, in particular if you're coming from abroad and you're not familiar with the system. So Works Councils are not mandatory. They are elected by the staff upon an initiative by the workforce. So it's not mandatory, even for very, very large companies.
Okay.
They can be elected in companies with 5 employees and
Right.
larger. And typically in the more traditional industries, the metal, the automotive industries, you'll find a lot of companies that have works councils, whereas at a very hip software company, they might not even have a works council.
So overall, sorry to interrupt, but overall, is it taking industry as a whole?
Sure.
Is it more common to have works councils where there are companies with, say, 20 or more employees, or is it 50-50, or is it still, it tends to be more concentrated in certain pockets, but others it's...
Yeah, it's probably industry related.
Fine.
So,
Okay, interesting.
but typically works councils are elected where it comes to restructuring situations or where
Yes.
staff reductions are being planned, and just employees want to safeguard their rights, right?
Yes.
So they
And
set
in
up a
that
works
context,
council.
I mean, in England, you can have a situation where you set up a works council that is a permanent body and is mandated to deal with any reductions in force or reorganisations, but it is there throughout. Or you can set up a specific body for a particular redundancy exercise or a particular reorganisation. Is it the same in Germany?
Oh,
You
that's
could, in
different.
theory,
Yeah.
set up a specific body or a...
No,
a
that's different. If you
Yeah.
set up a works council, it's there for permanently, and
Right.
it has all the rights throughout its
Its life.
it's being there. Okay, so and speaking of the rights of the works
Yes.
council, they are very far-reaching rights. So I think that's a different to the UK too.
Yes.
It starts with the hiring. If you want to hire someone, you have to go to the works council and ask them for their consent. It goes on with the transfer of people. If you want to transfer someone to a different position, you have to ask the works council for your consent. Dismissal, of course. And also they have a big say in social and economic matters. So when it comes to setting up social plans and restructuring measures. So, and these rights are all enshrined in the Works Constitution Act. There's a long list of rights. And there's no way for employers to evade that. So,
And when you say ask for consent, we might sometimes ask for consent, but we're pretty sure we know what we're going to do when we don't get consent. When you have to ask for consent, what happens if you don't get consent?
well, if you don't get it, you cannot force the measure. So you have to go to the Labour Court and ask the Labour Court to replace the consent of the Works Council. But there's a limited number of reasons how they can deny their consent.
Right.
So they can't just arbitrarily deny their consent.
So there's a duty on the Works Council to act in a particular way as well.
Yes, of
Because
course.
that's one of the
yes.
things that, and I don't think I'm generalising too much here, that's one of the things that's almost completely missing here as well. Just as the control on employers is pretty limited, there's even less control on what staff bodies can and can't do. So a staff body could probably reject any proposal for any reason whatsoever, and there would be no liability. Now, whether the employer might be able to go ahead regardless, but it's almost as if, in return for having greater powers to block the employer, there is greater responsibility for the Works Council in the way it has to act.
Yeah, it's actually the concept of responsible cooperation.
Yes.
That's actually the first section of the Works Constitution Act. So both sides are expected to work in a responsible manner.
Fascinating. I'm going to go on to ask, because again, one of the things I do know about is the levels of co-determination. I just want to delve down into that in a second. But I've got one question first. The Works Councils, who is entitled to be on the Works Council? Is it just employees of the organisation, or can external trade union officers come in and sit on the Works Council as a recognised union? How does that work?
No, the members of the Works Council are purely the employees of that particular site
Right.
or company or group.
Right.
So there's a site Works Council, like company Works Council, and a group Works Council.
Right.
And the unions, they can come to the Works Council sessions
Yes.
and support, but they are not members of the Works Council.
So the union can be invited by the Works Council to attend the sessions, but it doesn't
Exactly.
have a vote or...
No.
Right.
And as a matter of fact, unions and Works Council are strictly separated from each other in Germany, whereas in practice, obviously, they support each other, but legally they're separated and have different rights.
Yes, because over here, as an alternative to a staff council, you can have a recognised trade union, and you have no staff council, and you deal directly with the union, which then in turn looks to the workforce for its mandate and to be supported. So again, we have
That's a difference
slightly different way
Yes.
of doing things. Fascinating. So in terms of co-determination, again, just so I get this straight, hiring of staff, that is something you need the Works Council consent for unless you go to court and can overturn the decision. So you need the staff consent, the Works Council consent. Is that all staff hiring, or is it senior staff hiring? What's the levels?
It's actually all except for senior staff hiring.
Oh, fascinating.
So the Works Council never has a say on very senior people, on managing directors,
Right.
company organs. So this is not the electorate of the Works Council, and therefore he's not entitled to
Righty-ho.
give any opinion on that.
Okay. And does the same go for terminations then? If you were sacking the managing director, the Works Council has
Exactly,
no right to
exactly.
consent, but if you were dismissing a secretary,
Yes.
then it might well be...
Yeah.
Again, just asking how this works. One of the things that we bump into when we're doing consultation with staff committees, let's take a redundancy situation, is sometimes you are dealing with matters that are of importance to one individual only, or they are personal to one individual only. And there's always a bit of a tension with us about whether you would say to a staff committee, well, we're going to let X go, let that employee go in a redundancy situation because they've got a final written warning for sexually harassing a work colleague. You probably wouldn't say that. You'd just ignore it, and the chances of the staff council ever coming back and challenging you are limited. How does that work if you need to have consent from a staff committee to a works council, let's say, to make a redundancy? Is there any concept that you don't have to provide personal private details? Take my example of the person being dismissed is because they've got a final written warning on their record.
First of all, the Works Councils are all bound by the duty of confidentiality, so they're actually entitled to receive all the information they need for making their decisions, but
Right.
they're supposed to keep that confidential within the Works Council committee. And how it works in cases of dismissal, the Works Council, that's particularly for dismissals. If they're denied their consent, you can still go ahead and dismiss people. So that's possible. You do not need the consent for a dismissal.
All right.
It's only for hiring and transfer.
Fine, okay. Let's talk about dismissals, because again, this is one of the things that seems to come up again and again and again. Typically, English employment law, a client, often an American client, will ring up and say, how much is it going to cost to dismiss an employee? And by and large, in England, you can give them a budget. You can give them a number, and it's said it's unlikely to be more than this, it might be less than that. Great. Germany, much more difficult.
Yeah,
it's not
that's
France. I mean, France is
difficult.
impossible. We know France is impossible.
Anyway, not talking about France.
No, we're not talking about France. But so let's see. What's the dismissal protection regime in Germany, and then how does it work?
Dismissal protection is very strong and employee-friendly in Germany, and every employee in a site that has more than 10 employees has some basic dismissal protection, which leads to the fact that employers have to justify their dismissals by either personal conduct-related or business-related reasons, and also you might be obliged to conduct a social selection, so the least socially protected person amongst comparable employees will have to be made redundant.
Can I just stop you there? So
Sure.
you have statutory redundancy criteria.
Exactly. It's in the Dismissal Protection Act, and it's 4 criteria actually. It's disability, the seniority, age, and dependence.
Okay.
So these 4 criteria this is called our social selection. And if you have comparable, and say you have 3 secretaries, and you want to make one redundant, you cannot just freely choose who to dismiss. So you have
need to come and work in the UK. Trust me, we're allowed to keep the one we see as the strongest secretary.
Yeah, no. Performance is not considered
Why does
relevant.
the German economy do so much better than ours? I want to know at this point.
It's a social economy.
Yes, fair point. A point well made, I feel, in response. Okay, so you've got statutory criteria. Okay, so I diverted you down that question. But so dismissal protection regime in Germany, employee friendly. Statutory selection, so protected characteristics, and
Yes,
okay,
exactly.
fine. So just tell me a little bit about how does the protection regime in Germany work? What is the protection? Does it cover all the staff from the very first day they become employed, or is it like English employment law that some rights only happen after you've been there?
That's right. Yeah, we have a waiting period of 6 months.
6 months.
That's
right.
when the basic dismissal protection kicks in, but we also have some special dismissal protection, like maternity leave,
Yes.
parental leave, works council members, as a matter
Believe
of
it
fact.
or not, we have the same protections. We're not quite as barbaric as I'm pretending.
Yeah,
but
but there's a number of special.
Are there any special ones specific to Germany? I mean, the sense that we all have the same. As of today,
yes.
we all have the same
there's
common
a
euro
list,
protection.
There's a list. I probably, if I would try to make a list, it's probably a list of 100 or
What's the
something.
special protected categories?
Definitely. I'm pretty sure. Me as an employment lawyer, I don't even know all of them.
What's the weirdest one? Come on, what's the oddest one?
It's like the anti-money laundering officer is quite easy.
Right, okay.
But there's like people, the waste officer.
The waste officer.
So people that are responsible for waste.
Oh.
So it's
So
very.
If you dismiss someone because
I
they're...
know. Sometimes you don't
fantastic.
even know, and employers don't know.
Oh, fantastic.
So that can be a surprise in dismissal cases.
And joking aside, is it a case that they are protected if they're being dismissed for something to do with being the waste officer, or is it they
No.
are protected because they're the waste officer?
The second, and
Goodness.
it's impossible if you have special dismissal protection. It's almost impossible to terminate someone, or it's very hard.
All right, because I mean over here, you can dismiss a trade union official, for example. You can dismiss a pregnant woman. You just need to demonstrate to the tribunal's satisfaction that the dismissal is nothing to do with that protected status.
Well,
Protected status by
obviously,
itself, in almost all cases,
Yeah.
does not give you the right not to be dismissed. It
Right.
just there's
No,
a level of
as a
scrutiny.
general concept, it's not possible to dismiss. Obviously, there's exceptions, like in plant closures, where you just
Sure.
can't employ anyone anymore. So, but that's
In general
the
terms,
concept.
yeah. Okay, fascinating. So, and that's a general. So you have a right to only be dismissed for acceptable reasons.
Exactly.
Right. Okay.
Yeah.
And those are performance, conduct, and did you say business?
No, it's not performance.
You can't dismiss someone for underperformance.
No.
Sorry.
And you
Hang on.
can.
Are you sure you know what you're talking about here?
It's called a personal reason, actually. But
All right.
dismissing someone for performance reason is very, very difficult in Germany. And if an American client calls up and says, this and that employee is not performing well, how can we dismiss him? And I usually have to say that's not possible, because first of all, you have to go through a lengthy performance improvement plan and everything, and you have to demonstrate for a long period of time that he just cannot perform better. So it's very difficult.
All right, so let's just take that as an example. And if I were a typical client from outside Germany calling up and saying I've got an underperforming employee, and let's assume for a second that you're satisfied that I'm not motivated by discriminatory reasons or anything. It is genuinely an underperformance issue. What do you do?
You as an employer, you try to create other reasons, or you
Right.
obviously you try to approach the employee and try to find a mutual settlement, a mutual termination. So
Right.
speaking to the employee is always the first step, and then you might want to offer a reasonable severance payment so that it is attractive to the employee to accept such termination.
So, but what's the yardstick there? Because if the employee is able to say, and I'm going to caricature what you just said, you can't touch me because I'm only underperforming, and let's assume that there isn't a redundancy situation in mind. Why can't the employee just say, well, I'm 45, I want to work till I'm 60, so I'm not willing to go for less than 10 years' pay?
Yeah, well, they can, and oftentimes they do.
Right, and
So-
then what happens?
Well, typically you go in with your ingoing offer and then see if there's an appetite for some mutual termination. And also, speaking about severance payments, it's important to know that in Germany there's no statutory entitlement to severance payments at all.
Right.
So even if you're dismissed unfairly and not justifiable, then you're not entitled to a severance payment. But if you go to court, say you file a dismissal protection claim, the court will rule on reinstatement only, or not reinstatement if the termination is valid. So the court will not award any kind of a severance payment. They will just say the employee is being reinstated in his position, or he's not.
Okay. And when it comes to reinstatement, under English law, reinstatement is very rarely awarded. And even if it is awarded, the employer is let off if the employer can demonstrate that it wasn't reasonably practicable to take someone back on. And typically, where relationships have got fractured, the employer says,
Of course, yeah.
this is just not feasible.
It's
and
difficult.
English law generally does not make two parties work together if one or other of them is dead set against it. Bit of a generalisation. So under where reinstatement is ordered, to what extent does the court take into account whether it's practical, or is it simply a case of whether the dismissal was valid or not?
Yeah,
and they don't care whether it's
they
practical.
just look at the law. And what happens in these cases, it just basically rises the price, right, of the severance payment. So reinstatement, this is just a theory, but like I would say probably 80 to 90% of all cases are settled by mutual separation agreement at the end of the day.
Yes.
So it's just a matter of negotiations. Yeah.
Right.
So,
Fascinating. Okay. It feels like a system where it'd be difficult to work out what a dismissal is going to cost, because a lot of it will depend on the approach taken by the employee.
Yeah, no, it depends on, it depends on your chances of success when it comes to dismissal protection claim. And it's very common for dismissed employees to file such claim. I would probably say 9 out of 10 dismissal cases go to court. And just the employee has to safeguard his or her rights. And in that case, when the chances to defend the dismissal for the employer are good, then he is likely going to offer
Push the price down.
Yeah, the price is going to decrease.
So if I do a deal with an employee in Germany and they agree to leave, can I do a binding deal so that the employee can't sue me? Is there any protection?
Yes.
So, and does that have to be an independent lawyer representing the individual, as there is over here? Does the Works Council have to sign the settlement agreement?
No. The Works Council doesn't have any say on settlement agreements, so this is being individually negotiated. And if you enter into a proper settlement agreement, then all claims or mutual claims will be settled, and there will be no legal remedies at all. So.
Okay, but the individual doesn't have to be legally represented, because over here the individual has to have an independent lawyer sign off the deal. Yeah, we're more advanced than these. There's one area of employment law.
I mean, typically employees, they seek some legal advice, but it's not mandatory.
It's not mandatory. Fascinating. Okay. Let's talk about post-termination restrictions. I want to just cover off that area, because again, we know from some of the international work that we've done that restrictive covenants are very much an area of national law. There's next to no crossover. So talk about post-termination restrictions under German employment law. What are the typical types of restriction that you see? Let's just deal with them in categories, and then we'll talk about what's enforceable and what's not. So,
typically a UK client comes up and says, look, I have this employee is very knowledgeable and has lots of special know-how that we want to keep, and we don't want him to join a competitor after his termination. And then we'll set up a post-termination non-compete in the employment contract. And it has to be in writing. And typically it's agreed in the employment contract.
Sure. And non-competition. So we have clauses preventing you working for a competitor, clauses preventing you soliciting clients,
Yes.
clauses preventing you accepting work from
Yes.
customers, or clauses preventing you soliciting
Yeah.
your former colleagues.
That's all possible.
That's all possible.
You can be creative and whatever the employer wants to have in the contract. That's possible.
Not something is that something that's regulated by statutory law? Because you were talking about there are parameters for contracts.
Yes, it is. It is regulated by statutory law, and what's I think is different from many jurisdictions around the world is that post-termination restrictions in Germany come with a price tag, because you have to compensate them.
Yes.
So you have to compensate them by actually 50% of all contractual benefits for the time.
For the period of the restriction.
Of their life, right. Okay.
Is that all covenants, or is that just a non-competition covenant?
It depends on the degree of restriction.
Right.
So if a non-solicit is very, very restrictive, I will always say to my clients, for reasons of safety, put a compensation in, so you're sure that it's being considered enforceable if it's disputed.
So if it's sort of de facto a non-competition covenant because you are ruling out masses of people to be solicited, so effectively you're locking someone out of competing. That's the circumstances when you don't
exactly.
say
That you would rather put a compensation in the contract than not. So if you want to be in the safe side, you have to compensate. And a non-compete, you always have to compensate.
You always have to. Yeah. And what happens if you get to the end of employment and the employer says, I don't care, I don't need the non-compete? Do you draft it so employers have a choice at the end of a contract, say enforce or drop?
I would love to draft it that way, but statutory law does not allow. But there's actually an option to unilaterally waive the non-compete, but it comes with a 1-year notice period, and in most cases that doesn't help.
No, I can see that wouldn't help. Right. Okay.
So, but what happens in practice is sometimes people enter into a mutual waiver, and that's always possible if the employee agrees.
I understand. And what's the process for enforcing those? Imagine a client comes to you and says, I think so-and-so's joined a competitor or is about to join a competitor, breach of the covenant. How do you go about enforcing them?
Yeah, I actually just had this case this morning.
All right.
So we're about to go to court and force ask the employee to just stop working for the competitor, and this can be very quick. It's a very quick order by the court. Right. And we can also sue employee for damages, right? So if we can prove any damages.
Yes, often it's quite difficult to prove damages under English law because it's difficult to prove that the defection has caused loss.
Of course. But sometimes the threat of suing for damages does the trick.
Can you sue the new employer? Because under English law you can sue the new employer as well if they know that employing the individual is contrary to the restrictive covenant. We can sue the new employer as well, and there are all sorts of tactical reasons why you do that or don't do that.
Yeah, I think there is such concept under competition law, but I would definitely ask my competition law colleague. But I do think there is.
You could possibly do that. Yes. Okay, good. And under English law, the way it would tend to work is you can go to court and get an order often very quickly, within a few days, and the court will make a temporary injunction and say we'll have a quick trial, let's say 3 months' time, and in the meantime we'll give you an injunction.
That's right.
To hold
it's the same concept.
It's the same concept.
Yes. If something needs to be done quickly at court, it can be done.
Fascinating. Okay. Good. And typically, what are the length of the covenants that you've seen? How long is a typical non-competition covenant? How long is a non-solicitation of clients covenant?
This is actually a statutory maximum period. So the maximum period is 24 months. So that's the maximum, and I typically you don't see clients go that high because the compensation for 24 months is quite a bit. So typically I see ranges like six months to 1 year, maybe 3 months, maybe shorter. So that's market standard.
So 2 questions. If I have a covenant in my contract as a German employee for 18 months, can I say to the court, 18 months is too long for me, even if it's mandatorily permissible under German statutory law? Is a German court able to say this covenant is unreasonable and too long for this employee?
Yes.
Or provided the covenant is less than 24 months, will the covenant be enforced because it's below the length of the statutory maximum?
The court has some power to change the scope and the length of the restriction. But typically, if you draft it very carefully as an employer, and you provide for the right compensation, the right amount of compensation, and you take into account all the terms and conditions law restrictions, then you're on the safe side.
Safe ground.
So
okay.
proper drafting of the contract is key.
Yes. And final question on this. Under English law, we have a concept that during a notice period, the employee can be asked to stay at home. They can be suspended. It's not a disciplinary sanction, but they can be sent on garden leave. And typically, but not always, when drafting the restrictive covenants, you will take into account that if the individual is sent on garden leave, that should reduce the period of the restrictive covenant, because they've all, by the time the contract ends, they've already been out of the market for a period.
But that's different then.
Because you don't have garden leave.
Yeah, we do have garden leave. So yeah, the garden leave is very common.
Okay.
At the end of a contract, obviously, you don't want the employee sticking around the offices, so you send him on garden leave. But that does not shorten the period of restriction, because it formally just begins after the end of the contract, not after the end of his or her activities.
Okay.
So
fascinating. Okay, excellent. Good. Okay. I'd like to end with a personal question, if I may. I'm going to ask you. I'm going to ask you. I'm going to ask you your favourite travel destination and why.
Okay. Well, I probably my favorite travel destination is Indonesia.
Oh wow! Okay.
Because I've been there a couple of times, and it's a fascinating, very diverse country with lots of islands.
Right.
I think it's 15,000 islands or something. So I can only recommend.
So lots of exploring.
Yes, definitely, and all. It's very diverse.
Excellent.
So I can only recommend to go there.
Okay, good. Oh well, there we go. Let's learn something new. Good. All right, Pauline, listen, that's been fascinating. Thank you so much.
Thanks for having me, Nick.
I will, as promised, I'll post out a link to the podcast. Obviously, if anyone's got any questions, please get in touch with me. I won't answer any of them. I'll send them straight on to Pauline. But hope that was useful, and that was great fun. Thank you.
Thank you.
So that concludes this podcast. We hope that you find it and others in the series helpful. If you have any comments or questions, or want to know how to claim continuing education credits, please email Nick at nrobertson@mayorbrown.com. Thank you for listening to the podcast.